established, that is, felon in possession of a firearm, had been committed independent of Mr. Hernandez's admissions.
You're talking about the Corpus Delicti issue.
That's correct, Judge. The basis for that, as cited in both our briefs, both Harrison, this court's decision in Harrison, and I'm certain I'll botch this, Holzbacher. The state did not provide the body, the corpus necessary, to admit Isaiah Hernandez's unmirandized custodial statements, which we additionally contend were the product of interrogation or its equivalent, specifically police conduct reasonably likely to evoke incriminating responses.
Is it qualitatively different from identifying information? What's your name? That's not a problem. But if I say what happened, that's qualitatively different in terms of identifying and interrogation?
If I understand your question correctly, Judge, you're not asking about a distinction between asking for booking information versus what happened.
Correct.
You're asking if I understand you correctly, if there's a difference between interrogation and saying what happened.
Well, we have one, as I understand it, one deputy asked identifying information for what would be equivalent of booking information. And then there's another deputy that asked what happened. And as I understand your position, asking what happened was the kind of interrogation that should have been preceded by Miranda.
That's correct. However, the conduct, and it's Officer O'Leary, the second officer, and I apologize, I don't think the chronology in the initial brief was particularly clear on this point, and I apologize for that. Officer Leary being the second of the two law officers. In fact, it was Officer Nowak who testified, at least at the suppression hearing. I just wanted his name. I just wanted to know how to put his name in the notebook, which resulted in what I'll refer to, because I think it's consistent with the circuit court's order, is the excited utterance, which you recall was words to the effect of, "I know what I did was wrong, I shot the gun," or words to that effect. Not significantly different than the same statement he repeated subsequently. After we know at trial, Nowak tells O'Leary he's making statements. I don't know that Nowak said he made an admission. I don't know that that's what he said at trial. But he did say at trial that he, being Officer Nowak, that he indicated to Officer O'Leary, he said something to me. And it appears to be subsequent to that, bless you, that O'Leary goes and says, "All right, tell me what happened," which resulted in the public safety or officer safety exception as determined by the circuit court. Fortunately for you and me, it's our position that without the corpus, we don't ever have to get to that.
Okay, but let's talk about the corpus then. Because your client is charged with a 790.23 violation, possession, correct?
That's correct.
But what's the definition in the statute? Doesn't only include possession, it includes the care, custody, and control.
Well, and our position is the same.
Any firearm.
Our position is the same.
Care, custody, and control is broader than physical possession, is it not?
Judge, notwithstanding that, the state still didn't present evidence sufficient to indicate.
Okay, let's talk about that. Tell me if they presented evidence that the gun was in his immediate area. It was under the front seat and he had access from the back or the front on the passenger side, and he was in the passenger rear. Is that true or false?
I believe that's correct, Judge.
Okay.
But not exclusive, nor did they present evidence.
No, but then what's the standard? You're arguing over a judgment of acquittal. And what's the standard to prevail on a judgment of acquittal? You admit certain facts.
That's correct, Judge, and this court
fairly
reviews the
from the
application
evidence
of the
in
facts
favor of the non-moving party.
That's correct, Your Honor.
So, I mean, you couple that together, does that change your argument?
No.
I think I know you'll say no, but
no.
It's a rhetorical question.
Well, and at this point, as I stand before you, well, I shouldn't misrepresent, and I will concede. There are certain things that when pressed, I would have to concede in candor to the court.
And what are those?
Please don't, Judge. Please.
Move on. You don't have to give anything in violation of your Fifth Amendment rights.
And Judge, here I was all prepared to acknowledge that we don't need to discuss Ramirez because I think it's taken that, I think it can be safely concluded that he was in custody. And the only reason Ramirez appears in the brief is to the extent that we need to discuss whether or not he was in custody at the time of the interrogation. But I wasn't going to bring that up.
All right, well, that's okay. You can bring up whatever you want in any order you want.
He was also charged with the misdemeanor discharge. But all those others and the marijuana, all that was severed for trial. Doesn't change our position any. What they presented evidence of was...
I mean, you agree circumstantial evidence can be used
Absolutely.
to establish corpus delicti.
Absolutely. But
So-
what was the circumstantial, of course rhetorically, what was the circumstantial evidence in this case? What did Mr. Borgia say he saw? And in fact, factually, it's our position that this case and Harrison are, on all significant facts, they're indistinguishable. The primary difference in this case factually and this court's decision in Harrison is that in this case, there was evidence that we don't dispute that a firearm was in fact discharged in public.
But a gun was also found within reach of your client, unlike Harrison.
That's correct, Judge.
Okay, thank you.
But not to the exclusion.
And two witnesses heard the actual gunfire and placed your client at the scene of the gunfire.
That's correct, Your Honor.
And then you have temporal proximity. The officers are right there, a couple hundred feet away, I think it was.
Not very far, within
Okay.
seconds, I think.
Okay.
His testimony was fairly consistent, that he responded within
So we
seconds.
have everything but a video and no eyewitness to your client actually holding the gun, but he's making furtive movements. There was an eyewitness to that. Allegedly, it was him because he's the guy with no shirt and tattoos.
Okay. There was a guy with no shirt and tattoos.
May or may not have been your client. We don't have positive identification, but we
even
have
if-
circumstantial.
I think probably more likely than not was in
Okay.
fact,
Okay.
based on the proximity and time between Officer O'Leary arrived. But what did Mr. Borgia testify to at trial? Did you see a gun in his hand? No. Did you see a gun? No. In fact, his testimony was that the shirtless tattooed man, who we concede in all likelihood probably was my client, that he reached behind his back, at which point Mr. Borgia took cover. Now, what else does this record support, though? 2:30 in the morning, the early morning of December 31st. Last call's been made.
All right.
Streets are filling with people. I mean, I think that's consistent with the record. And what did Officer O'Leary testify to consistently at suppression and at trial? As he approached, these people are essentially milling around. He testified that some people were pointing in the direction, not just of
Well,
this.
there was words, and people were drunk, and there was words between one group versus another group, or individual versus individual, before the bars let out, right?
That's consistent with, the record supports that,
Okay.
yes, Your Honor.
Okay.
But they were not,
It seems to me you're arguing a rule that would require that somebody would have seen your client with the gun. And it just strikes me that that's beyond my general understanding of what you need to establish for corpus delicti. I don't have to show that he had the gun, do I?
Judge, what's problematic factually, and this goes back to Judge Volante's questions, I think, as well. This wasn't a gun recovered along the roadway. This wasn't, like Harrison, a gun recovered, similar to Harrison. No gun was recovered from either Harrison or Hernandez. It was recovered under the seat. He was a passenger. There were two other human beings in the vehicle. There was no testimony.
Neither of whom matched the description that was given to the deputies.
But Judge, no one saw my client fire the shots. So what even Officer O'Leary testified to was that as he rolled up, all these other people, and I don't know how many,
Where were the casings found?
they were found not only near where he testified he saw my client standing, but as Officer Nowak testified, they were found near the
Now,
vehicle.
am I remembering the following correctly? As your client got in the car, it starts moving away from the officer, even though the officer yells something to the effect, "Hey, wait, I want to talk to you." He keeps going, gets in the car starts leaving. And
Judge,
one of
you
another officer, I believe, felt threatened.
Judge, I don't know that that's necessarily consistent with this record. Because
But is it consistent with the standard of review on a judgment of acquittal being denied? Is there an inference there that we have to give the state the benefit of?
had the defendant been the only person in that car, I don't think I'd be standing here talking about the fact There was no testimony in the state's case in chief where going to say it wrong again, Holzbacher required.
Close enough.
Right? And you know what came up in the answer brief?
Right.
Well, he testified on his own behalf, and we have that, and we have his brother's testimony.
Well, that brother
Total
was
mess.
inconsistent. Something was wrong there.
Absolute mess in the
Right.
defense case in chief. Good thing we don't need that on a judgment of acquittal at the end of the state's case in chief. State bears the burden. There was no testimony. This record doesn't support that in the state's case in chief, Isaiah Hernandez knew the firearm was under the seat. And I think, Judge, to get to what seems to concern you the most, to exclude those other two adult occupants, and honestly, I think the characterization of facts, Judge, even when O'Leary, and I appreciate that Officer O'Leary's adrenaline was doing things that happen in the line of duty. When you hear shots and you see...
Well, what do you think about, how do you factor in the public safety exception under your facts?
If you go back to the suppression hearing and read Officer Leary's own words, he will tell you, unless, I mean, of course, subject to being contradicted, what the record says, what the record says.
Right.
The first person he spoke to was the driver. And the driver said, the gun's under the seat. Now, we know from Officer Peace or Pease, the gun was in fact recovered, exactly where the driver said. So, having asked and been told, yeah, I know the gun, I think he said it was the brother, Hernandez.
I know, but because the driver may have identified where the gun was hidden, does that eliminate the prospect of care, custody, and control of your client?
I think those
Isn't
are
that a
two-
jury question?
I think, no, Judge. I think there had to be sufficient facts presented to the jury on the crime, felon in
So
possession.
you're saying there's a gatekeeping duty that would eliminate the care, custody, control issue as a matter of law that the trial court didn't perform here?
Seems to me there's enough circumstantial evidence, though, to make these elements that admittedly there's no direct evidence on.
Judge, and I don't think, and if I stated this in the brief, then shame on me for doing it incorrectly. I don't think this is my beef, so to speak, to use the term of art, I don't think is with the fact that this was circumstantial evidence. I think the fact we had two other warm bodies, we had shell casings found near the vehicle. I mean, that's Officer Nowak's testimony. We didn't have testimony that I recall about how far a Ruger LC9, I think it was, would eject brass, the semi-automatic pistol. And what we do have is these other people in the street who apparently were having no more reaction to this event than, according to Officer O'Leary, they were pointing in the direction of the shirtless man who was probably my client, which was also the direction of the vehicle. So when you take the fact like Harrison, no one took the stand and said, I saw him with a firearm. Because the state didn't present any evidence to exclude it was in the possession of those other two individuals, I think that's
But
the
you're
heart.
saying that's a reasonable hypothesis of innocence.
Well, I'm
that's
not,
really, you're not using those words because you don't want to make it a circumstantial evidence case, but in order to process this, that would have to be a reasonable hypothesis of innocence. That was one of those two other people that were already in the car.
Well, no, Judge, I think the state's got to prove their case. And there were three people, and they didn't prove, it's our position they didn't prove it was my guy. I don't think we ever get to...
You
To
never
the-
get to a jury. Okay.
All they're going to do is show that there's some evidence that a crime was committed, and then they can take his admission. Your test is somebody had to see him with a gun in his hand, and I'm struggling with that.
Well, that's not my, and of course, we take the facts as we get it, and the record. All those people, no testimony in this record about what they did when these shots were fired. If they looked, if they didn't look, what they saw, if they didn't see. The test actually on Corpus isn't a crime, it's this crime. Not discharge in public, which we concede there was enough evidence, circumstantial and direct. Officer O'Leary heard the shots, Mr. Borgia heard the shots, there were shell casings found, though no ballistics were ever done, but still, I mean, there were .380 caliber shells in close proximity to both the shirtless man and the vehicle. Okay, all of that substantiates, sufficient to get to the jury, that the crime of discharge of a firearm in public took place. But it's not, excuse me, I'm waving my hand and hitting the microphone. The standard is not sufficient evidence of any crime and then this crime gets to the jury. It has to be the crime of the type charged. And they had to give him something to put that it was in his custody or control or in his hand. And I'm harping on the hand part because with all these warm bodies. Now, Officer O'Leary testified when he came around the corner, the gentleman had his back turned, he was walking away. He testified, I called out to him, but I can't honestly say he heard me. And I think that matters. Because if Judge Valenti, as he just characterizes it, he rolls up on the scene, he's concerned. He says, whoa, 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 stop. And the guy disregards it. Of course, then we're talking about flight being evidence of culpability. But Officer O'Leary he says his back's to him the whole time. I don't know that he heard me. And then he did what one would expect anyone to do at 2:30 in the morning when last call's been announced. He got in the car. They wanted to go somewhere else. I mean, I don't think that's a stretch. But where was Officer O'Leary standing at that time? I believe from his testimony he was standing in the middle of the road. So what were they doing? I don't know. The record doesn't. They were talking. Do we go over there?
But doesn't Rhode Island versus Ennis give us a pretty high standard that this dialogue has to meet before we consider it to be an interrogation? I mean, did it really? I mean, did it reflect the compulsion that's above and beyond the inherent custody itself? You know, as that case instructs us. I mean, it seems like it's got to be something more than we have here. This was, you know, it's difficult to really characterize this as any sort of compulsive questioning that went on.
Well, Judge, I would, it's a lot easier for me to address Officer O'Leary walking over saying, what happened? Because that, I could say, is
who's he directing that
to my client.
I sort of got the idea that that was generally directed at whoever was over there, which included your client and others.
At that point, it's my understanding they've all been cuffed. They've been separated. There was some testimony that my client was trying to talk to his brother as they were being handled. It's my understanding from my reading of the record, Judge, that it's fairly unambiguous, even from O'Leary's own mouth. I went to the defendant.
But wouldn't that second admission become harmless error if the first admission was a spontaneous declaration in answer to Officer Nowak's questioning about identifying data, what's your name, and that sort of thing?
It would. And the weakness...
And you don't need PC to question your client of the specific crime of a discharge of the firearm or possession of a firearm at that point, because they already had PC for a stop in view of the flight and the car moving towards them. They were going to protect their safety at that point.
The officer had heard the shots. So until there was going to be a certain amount of latitude. And at the suppression hearing, Officer Nowak was unambiguous that I was just going to ask him his name. I didn't even have a chance to ask him his name, and he blurted it out.
That's a problem. That's your biggest problem.
That's a problem. He testified differently at trial.
The other problem is you're down to 2 minutes, but you can keep going.
I can't believe, Your Honor, I'm not at 37 minutes at this point because, frankly, it's fun.
Well, we've only got one case in the docket, remember?
And I appreciate how much
This is not Atticus Finch time.
At trial, Officer Nowak said, once my client was in cuffs, he escorted him over to that bench alongside the road for the purpose, and I'm sure I'm misquoting it, but a lot of the words I feel are correctly, for the purpose of finding out exactly what was going on. That's not booking information. Now, I have to concede that wasn't available to the trial court at the time of the motion to suppress. Our position, and to get back to your Ennis question, Judge Morris, because I will never miss an opportunity to mispronounce a case name, probably to the humiliation, because there are probably people in the room who are involved in the case. But in citing Rhode Island versus Ellis, Echevarria, cited in the brief, starts with an E.
You're doing fine. You're doing fine.
We're not just looking to the questioning. And I think what happened, that's not what's your name. That's not asking another officer what's going on here. I think it's pretty clear. What happened expressly calls for incriminating statements. The problem being that excited utterance that occurred prior. And if Officer Nowak escorted my client over to that bench for the purpose of finding out exactly what was going on, that's police conduct designed to do what? Find out exactly what was going on.
Now, you have used your 2 minutes. If you want to stop now, I will give you an extra 2 minutes for bonus coverage in the rebuttal round, in Final Jeopardy. You want me to save you those 2 minutes? I'll do it. I'm going to go to your opponent, and he'll get extra 2 minutes if he needs it. Fair enough?
Judge, I'm caught between doing what's right by my client and the fact that having 4 minutes, I would like.
I gave you 2 extra on the tail end.
I would like
the
to.
front end.
I would
You want
like
to save
to.
them? Okay.
I would.
You
please.
got it.
Thank you.
All right, let's move on. All right, you heard my offer. If you need those 2 minutes, you're happy to share them.
Yes, Your Honor. May it please the Court, Peter Koklanis for the Attorney General's Office. This is a case in which the defendant confessed twice to 2 different officers, and the trial judge correctly ruled that Miranda warnings were not required for either confession under these circumstances.
Well, the guy's handcuffed. He's sitting there with his hands behind his back, and the second officer asked him a question. What happened? That's designed to get incriminating information, isn't it? Because you suspect this guy of a crime.
It may very well be, but what the trial judge points out...
Are you trying to tell me that's not an interrogation?
It may very well be, because the definition of interrogation is reasonably likely to incriminate. Even if it's not certain, it may be reasonably likely. The entire point of the trial judge's order, though, is that under circumstances in which the public safety is in jeopardy, officers simply don't have to read Miranda.
Was the jeopardy gone at that point? They recovered the gun, the guys were in cuffs?
They had not recovered the gun at the point
They're still
O'Leary
searching,
said.
but the guys are
Correct.
in cuffs. They're not about to use the weapon.
Well,
And saying what's happened is not the same as, where's the gun, where's the gun?
Well, that's a good point, but I think it's important to note that O'Leary testified at the motion to suppress hearing that he did not know what happened. He didn't know there was only one
There had
gun.
been no communication, so he didn't know this guy was going to blurt out for a second time that he shot and he needs to be punished.
Correct. And even if he had known that information, the initial information to know, like, I shot the gun, doesn't alleviate all of our concerns.
Well, what's your backup argument? If this was a custodial interrogation, what's your backup argument to save the day for the state in this appeal?
That public safety concerns existed.
What's your other backup argument?
That it was harmless
Is it
error.
beginning with the word harmless error?
That it was harmless error because the first confession obviously was cumulative to the second confession.
Okay.
Either one is a direct admission that he shot the gun. At that point, they're completely cumulative and duplicitous.
Okay, what's the argument that he wasn't in custody related to the first interrogation?
The first interrogation was in which Nowak said, "What's your name?" And the exception, the case law carves out an exception for biographical questions under McAdams and Timmons, in which generic questions like what's your name, what's your address, date of birth.
Booking type information like
Exactly.
Judge LaRose alluded to.
Correct. So that was not interrogation at all, and the backup argument to that would again be the public safety exception. So I'll touch on the public safety exception a little bit more.
Yeah, that's that's rarely used, isn't it? It's not the most common doctrine.
It is. I haven't seen it that often. But the case law is very clear, and it's still good law. In the U.S. Supreme Court of New York versus Quarles, the Supreme Court established this public safety exception, and I'll briefly summarize that case so we can compare the facts. In that case, a woman had been raped, and she identified to the police that her rapist had gone into a supermarket nearby and said, he has a gun. The police go into that supermarket, they chase the guy around for a while, they catch him, and they find he has an empty holster on him, and there's no gun in it. So they ask him, without reading Miranda, where's the gun? The court says in that situation, the gun presented a risk to the public safety because there was a missing gun in a supermarket where any kid or person could find it.
No, but had a gun actually been connected to the defendant in this case? You know, the Quarles case is a pretty heavy-duty case of the public safety exception. Do we have the same factual comparison here?
No, but I don't think there's a limitation on the connection. The purpose of Quarles is to empower the officer to ask questions regardless if it were
some sort of reasonable basis.
Correct, and to be addressing the public safety.
And you can use circumstantial evidence to establish the reasonable basis.
Exactly.
All right, what have you got to establish the reasonable basis here?
Well, even if there wasn't a reasonable basis, then the officer would be free to just ask him as he's free to ask anyone on the street what happened. He could have asked a civilian what happened.
But he wasn't suspected of being a witness, was he?
The defendant?
Right.
Well, if he's involved, he's a witness by definition who knows information.
Well, that's the trouble here, because there are a number of people the officer could have directed those questions to that would not have the implications of directing them to the defendant who was handcuffed and clearly not a threat to anybody at that point. So it's difficult to sort of think that, you know, that we can so easily disregard the defendant's right to remain silent and argue it's a public safety, you know, exception that he can be asked a question which otherwise would be impermissible and which could easily be answered by the array of people that were involved in this thing.
Well, one of the things the Supreme Court points out in New York versus Quarles is that we have to empower officers to be spontaneous and quick. We can't judge them in hindsight, Monday morning quarterback, they could have done it differently, they could have done this. That's exactly what the dissent tried to do in Quarles, saying, well, couldn't they have cordoned off the supermarket, quarantined it, and then just meticulously looked for the gun? The majority says no. The officer's got to find a gun, and he's got to find it now. The fact that maybe they could have done things differently or looked at the video footage of the supermarket, that doesn't matter because every second counts. So here, the officer had this guy in custody. He's right there. You know, he arguably is a person who knows the most about it because he was fleeing the scene, and people were pointing at him.
It seems to me, though, of the three stages of this argument, the second questioning is really the least significant, because even if what the officer did was wrong, it's probably going to be harmless error if the first statement comes in, correct?
Yeah, that's fair.
The first statement isn't going to come in unless we can determine whether or not the state's proved the Corpus Delicti first. So you might want to talk to us about that, because obviously the evidence is real thin on a number of those elements.
Can I ask you, doubling up on that, the Quarles case, I mean, we have an empty holster. It seems
Correct.
to me that's a little different. I hear Mr. Upson correctly. There's very, very slim evidence linking the defendant to possession or control of a firearm.
I don't think there's a nexus requirement in the New York versus Quarles case. There's a public safety exception which focuses on the public safety. So it's the degree and reasonableness of the concern to public safety that frees up the officer to kind of shoot from the hip. And the phrase that the court uses
No
is,
pun intended, right?
is spontaneity and quick action is the order of the day. So he's allowed to just fire off questions at people who might have the answers because the answer to those might allow him to make...
I'm trying to focus on something else.
Okay.
The fact that the fellow had a holster,
Uh-huh.
an empty holster, sort of suggests that he had the gun.
Correct.
In our case, there seems to be very, very little evidence linking the defendant to the possession of the gun that was ultimately found in the vehicle.
Well, the officer didn't ask this defendant specifically about the gun. He asked him more generally what happened, because at that point in time, he was trying to determine what happened, and there was reason to believe that this person knew. The crowd was pointing in his direction. He was fleeing the scene. He had a demeanor that was shouting and angry at the time, and he got into a car that ultimately attempted to flee as well and attempted to exit that car. So the state's position is that, I'm not sure the crux of your question, if this is getting at it. However, the state's position is that he reasonably was seeking information to be able to react to that.
I guess I'm being overly obtuse. I'm trying to focus on the Corpus Delicti.
Okay. Well, then I'll come at it from a different way.
Go with your non-Ivy League answer.
Okay, I'll try. Well, I'll start out by pointing out that the Corpus Delicti is designed to prevent convicting for a non-existent crime. And the case law is very clear that the standard the state needs to meet in order to admit that confession is very low. It's prima facie evidence or competent substantial evidence, and the case law makes clear that it can be circumstantial. It does not have to be beyond a reasonable doubt. It can have varying interpretations and does not have to be overwhelming or indisputed. So what is the evidence here specifically? The evidence is that state's witness Borgia saw this shirtless, tattooed man reaching behind his back in an aggressive manner, and then immediately after that, Borgia and his girlfriend turned to get away, gunshots ring out. Now, admittedly, he didn't see the actual gun because he's not going to stand there and stare at it rather than get away from it. But a reasonable person can conclude, what are the chances that someone else shoots off a gun at the exact moment you're reaching for it? And in particular, the defendant's demeanor was consistent with someone who did that, because he's visibly intoxicated, yelling profanities, saying rude things to this couple. Then, also independent of his confession, Officer O'Leary gets there, and what does he see? He sees this exact same defendant, who he can identify, in that exact same condition, angry, swearing profanities in the road, still shirtless, tattooed, the only shirtless, tattooed person in the area, standing in basically what's a pile of bullet shells in his direct area, 38 caliber shells. The defendant
That matched
then,
the gun that was found under the seat.
exactly, that was a 38 caliber as well. And this defendant then walks away from the officer and ignores his commands to stop. That's evidence of flight or evasion. There are also people pointing in his direction, and the defendant then gets into a car, which the car begins to flee. Now, granted, the defendant wasn't driving that car, but it's a reasonable inference that he was either telling the drivers or they were acting on his behalf in fleeing and trying to get away. And then, of course, you have the gun itself.
That's a big leap.
It is, but
Mr. Upson, if I believe Mr. Upson, the officer doesn't even know if the fellow heard him as he was walking away. You're asking us to stack a lot of things together.
well, the case law says that each piece of evidence doesn't need to establish the corpus delicti individually. It can be considered in concert. And what the officer also testified to was that he was speaking very loudly, and he did say stop multiple times. It's also coincidental that the defendant who's standing there decides to leave suddenly just when the officer happens to be there and get in a car, which also quickly tries to leave, even lurching forward towards the officer as the officer's pointing a gun at it before finally stopping. So, granted, there can be a reasonable inference that he didn't hear it. There can also be one that he could have. Again, we consider all this evidence together. And then, of course, we've got the gun, which is found in the car, literally within arm's reach of the defendant, directly under the passenger seat in front of him, the same caliber as the bullet casings, also in an empty condition with no bullets in it. So, given all these facts together, a reasonable fact finder can exclude every other inference other than that he was involved in the crime. And specifically, there's one more thing I want to point out about the confession itself, which relates to corpus delicti, and that is that in his second confession to O'Leary, he said, "I got into it with a couple, I shot the gun." Now, there's a unique detail in there about getting into it with a couple. And the reason that's relevant is because witness Borgia testified that he was with his girlfriend, that's a couple, and he got into it with a shirtless, tattooed individual who made a motion exactly like drawing a gun. So that mirrors the defendant's testimony and confirms it, because how else would the defendant know to confess to getting into it with a couple if he was in fact just having this entire confession as a delusion, which is what the corpus delicti rule is designed to prevent. So the state's position is that the trial judge properly ruled, and there was ample evidence from which independently to confirm that his confession was real, was not a product of derangement, and that the crime in fact happened, and send this case to the jury. If there are no other questions about that, the state respectfully asks you to affirm the conviction and sentence. Thank you.
All right, thank you. All right, Mr. Upson, I promised you 2 minutes, and I've got them for you right here.
Thank you. Thank you, Judge. I joked earlier this case appeared simple at first, and the more I messed with it, the more it was like an onion, and the more layers I peeled back, the more I cried.
I like that. I might steal that.
That may be a good sign that I reached that point. When a law officer takes a man in handcuffs to a bench to find out exactly what was going on, any statements that come out of that man's mouth as a result aren't spontaneous. That's the police conduct, police procedure that Ennis talked about that was designed to elicit incriminating responses. I'm not going to revisit, not just because of time, but the public safety exception I think the trial court was just wrong about. I'm a lot more concerned about the first statement. Fortunately, for me, I have problems obviously with the corpus. There's no issue that a firearm was discharged in public. That's not the crime Mr. Hernandez was tried for. And Judge, I know it concerned you that it sounded like I was saying, put the gun in his hand, put the gun in his hand. And frankly, somebody put the gun in his hand. Officer O'Leary said when he testified that I got there and the man was walking away.
You got about a half a minute to wrap up.
Thank you. as the man was walking away, and I can't say that he heard me, the officer testified to at trial, that he was agitated. How was he agitated? Well, he was yelling, and I believe he said he was waving his arms. And you know what Officer Leary didn't see? He didn't see a gun. So somebody that drunk and that agitated to fire those shots and have the presence of mind, well, I mean, he can't make for a gesture like he's going to reholster it. He's not wearing a shirt. So it's got to go in a pant pocket. The state needed to do something else, that the felon possessed the gun. And those two other people, they didn't do it.
All right, that'll do it. That concludes this